won't be able to verify it, and we won't take your word. So just go, okay? Everything's on your paperwork. The steps you left, we give you a copy. Good luck next week. If all goes well, you should be out in time for this.
Yeah.
All right.
Thank you.
Sounds good. Mr. Reichel? And then Scott Humphrey, will you go to the chair? Hi, sir. Can I have your full name and your date of birth?
Christopher Reichel, September 19th, 1989.
Okay, thanks. You're on a new case. You were arrested for domestic violence, assault, disorderly conduct, criminal damage, and preventing the use of a telephone during an emergency. The first three are Class 1 misdemeanors. The telephone count is a Class 2 misdemeanor. There is probable cause for all of those. I'm not appointing a lawyer for you, sorry. Your arraignment hearing is going to be October 21st at 9 in the morning. If you want to try to qualify for court-appointed counsel, you have to fill out paperwork at Peoria City Court. They may or may not do it. That is their decision. I'm releasing you on your own recognizance with no victim contact orders. From the way the police gave me the probable cause, it appears the alleged victim does not live at that location. They didn't say whether you did or you didn't, but she appears not to live at that location. So I'm not ordering you not to go back there. Sounds like it's your common parent's house.
Yes.
Are you living there?
Yes.
So I'm not prohibiting you from doing that unless your parents kick you out and then you got a different problem.
Yeah.
That's between you and your parents. They're not victims in the case. So if your sister comes over and your parents tell you to leave so she can come over, you got to do it, because if you stick around and she shows up and the police get called, you get arrested.
I understand.
So, absolutely no contact with your sister, even if she shows up at the place you live, because I cannot, nor would I, order her not to go to her parents' house. She's the alleged victim in this case. So she's under no court order to stay away from you. You're under a court order to stay away from her, which is enforceable by criminal statute. So it's a criminal case. Don't monkey with it. It's not an order of protection. It's a criminal release order. There will be consequences if you get arrested for violating it. No weapons, no drugs, no alcohol. They accuse you, and there appears to be some evidence of being an alcoholic. I'm not going to make you alcohol test. I can't do that in the city court. I'm saying you're prohibited from drinking. No weapons or drugs without a valid prescription. If you get served with an order of protection, then you have to comply with that as well, only if somebody serves it on you. And that would be anybody. Like if your parents were to serve one on you, you're stuck complying with that. Anyway, everything's on your paperwork, but based on your criminal history, I'm willing to release you. I'm not seeing a pattern of this, and I'm not seeing, I see a DUI, I see drug paraphernalia, and an FTA. So I'm not seeing, I see an old, by the way, everything sticks around. 2009, you were arrested for criminal damage, domestic violence, but it got dismissed. So I'm just saying, we get granular detail on some of these criminal histories. So I'm releasing you. Don't monkey with release conditions. Everything's on your paperwork. Don't miss your court hearing.
Yes.
All right.
And I'll have to do my research, but are those charges that she can still drop?
No.
Technically?
No, she's not up to her. So, and by the way, witness tampering is a felony. Attempting to influence a witness's testimony is a felony. Committing one act in violation of my no contact order is aggravated harassment, a felony.
Understood.
I put the statute in your paperwork. Google that or aggravated harassment statute. You could send her one text, and if the police booked you in and the court found that that text was harassment, that is a felony. So serious consequences. Your court date is not for 3 weeks, October 21 at 9 in the morning. I believe you should be able to comply with these release conditions without a lot of effort. If you prove us wrong, you'll find out what happens, whatever that is. So it sounds like you understand it, and you'll comply. Yes?
Yes, ma'am.
Great. Then you are released. It still takes many hours to be released. Try to be patient. That's just part of the joy. But you should be out hopefully by dinner time tonight. All right.
Okay. Thank you, Your Honor.
All right, Mr. Humphrey. After that, Elvis Klein. We go to the chair, please. Hello, sir. May I have your full name and your date of birth?
Scott Humphrey, March 17th, 2003.
All right, thank you. You were arrested for reckless driving, a Class 2 misdemeanor. There is probable cause for that, and I am appointing a lawyer. No, I'm not. Sorry. I just say that so routinely. I'm not appointing a lawyer for you. We don't in this type of traffic misdemeanor unless you get a bond. I'm not planning to give you a bond today. I thought about it, and I will say that what they allege against you, as I noted in my order, appears to be particularly egregious and very deliberate. And it's the kind of behavior that the rest of the people on the road wish there was a cop around to see when somebody does it, because splitting traffic, cutting tightly in and out between cars on a motorcycle, startles drivers and can cause people to die. and, you know, the recklessness that they allege against you could easily be charged as aggressive driving, which is a class 1 misdemeanor, more penalties. The state could still do that. But we do not set bail based on how much we dislike what a person is accused of. We set it based on objective considerations of whether we think they're likely to appear, whether we think they're likely to commit new crimes, whether we think they're likely to comply with other release conditions. You don't appear, the police did not tell me that you have any other criminal history. I don't get it separately in a misdemeanor case. The police have to do it. They didn't say that you ever even been arrested before. So I'm going to presume that you have not, and that you don't like being arrested, and that they very likely impounded your vehicle for at least a month, which would tend to reduce the likelihood that you might commit this type of crime while you are pending this case. I will tell you that this exact type of driving behavior, if someone is hurt, could get you charged with aggravated assault. If someone is killed, could get you charged with second-degree murder by gross recklessness and extreme indifference to human life. So, with that lecture, and hoping that the overnight in jail was very unpleasant such that you wish to avoid that in the future, I'm going to release you on your own recognizance to go to court October 22nd at 9 in the morning. I considered also ordering you not to drive. I have not done that because, again, we don't set bail based on how much we might dislike what someone is accused of and how many times we might sign warrants and do these hearings for people who do get accused of murder based on speed alone. So, Mr. Humphrey, will you comply with these conditions and come to court?
Yes.
All right, then you are released. It still takes many hours to be released. Try to be patient. If you step to your left, he will give you your paperwork. Thank you. Mr. Klein? And then Sabrina Sedana, will you go to the chair? Hello, sir. Can I have your full name and your date of birth?
Elvis Christian Klein, and it's at 5799.
Okay, thanks. You're here on a warrant from University Lakes Justice Court in a criminal trespassing case. It's a class 2 misdemeanor. This is a failure to appear warrant, and your arraignment hearing is going to be October 21st at 1:30 in the afternoon. That's about 3 weeks from now. I'm going to release you on your own recognizance because I looked at the court record and I saw that you've been to court at least a couple times. This is your first warrant, and it is criminal trespassing, which is on the continuum of offenses, less dangerous. So it's your first warrant. I am going to give you a do-over. Don't blow it, because then you'll come back and somebody will see that you came through jail, you got a do-over, and you blew it off. Don't blow it off. Show up. I know you know how to call them because their court record says you called them before. So if you have trouble getting there, call and ask for a different court date. They'll usually do it if you do it before the warrant goes out. So give them a call if you can't make it. You got 3 weeks to get there. Will you do that?
Yes, ma'am.
All right. Also stay away from wherever this was.
Okay. Yeah.
Right.
Wait. So am I still trespassed from ASU?
That I'm ordering you not to return to the scene of the alleged crime. If that was ASU, then yeah. But I'm not trespass. They trespass you. The ASU can say you are disinvited from ever setting foot on our property. They do that. What I do in the criminal case is I prohibit you from going to the scene of the alleged crime. Sometimes I know that might be the entirety of the ASU campus. Sometimes I don't. It's also true to say that I don't know when somebody might be a student and when somebody might not. But if you've been trespassed from ASU, they don't forget.
Yeah.
So you're going to get arrested. You could also be booked in for the misdemeanor of violating this order. So all I can tell you is, if you believe you have a legal right to be there, that is between you and ASU, because they can trespass people who are full-time, fully paid students. They can trespass them. So that's a civil issue right now. They haven't. I'm not being asked to find probable cause because this is an old case. Probable cause is already found. This is just a warrant. If you go there again, and then they book you for it, I would have to find probable cause, but this is a pending case. So I don't even know what you did, except now you have sort of told me. So, or allegedly did, sorry. I'm releasing you. Go to court. That's the main thing. Stay away from wherever this was. Everything's on your paperwork. You'll be out in a few hours. Be patient. If you step to your left, you get that paperwork.
Thank you.
Thank you.
Have a good day.
Good luck.
Thank you.
Ms. Sadana, and then Robert Bender, we go to the chair. Hello, ma'am. Can I have your full name and your date of birth?
Sabrina Marie Moreno Saldana, 25-2000.
Okay, thanks. You are before the court on a total of 3 things. One's a new arrest, 2 are probation holds. In the new case, you were booked in for possessing narcotic and dangerous drugs. Those are class 4 felonies. And the probation department has notified the court that they plan to file petitions to revoke your probation in both of your cases. Looks like you're on probation for 1 felony and 1 misdemeanor. So I'm going to give you a lawyer in all of the cases, and I'm going to give you some court dates. The first one is going to be October 9th, which is 1 week from today. That's the probation court date at 8:30 in the morning. It's on your paperwork. It's in the downtown Superior Court. Then the week after that, you're going to go for the new case on October 16th. That's a status conference, 8:30 in the morning. Preliminary hearing, October 20th at 8:30. So you don't have any other conditions in this case. I did check the box to give you the probation phone number because your terms and conditions require that you call your PO within 72 hours of any release from any jail. So don't forget to do that. I didn't find probable cause for the drugs, though, for purposes of this hearing only. So you're entitled to be released with no other conditions. You don't have bond. I'm not ordering you to do anything. I'm reminding you to call your PO, but otherwise you don't have any conditions. Because what the law says is that when I don't find probable cause on a new charge, you're entitled to be released, but I do not dismiss cases. The county attorney can still go forward on this, which is why I gave you a lawyer and I gave you some court dates. Otherwise, you're going to get released.
So I'm getting OR?
No, I guess I'm saying it's not even OR.
Yeah,
you're just released.
Right.
You don't have to promise me anything. You're just released. OR is your promise to do things. You don't have to promise anything. I didn't find probable cause.
Okay,
I'm just telling you, your
saying.
terms and conditions always require you call your PO within 72 hours of release.
Okay.
I click the button on everything because it prints the phone number. Then you have no excuse. You can't come, you didn't know my PO's number. Yeah, you did. I gave you the main number. So just do it. And smart people, when this happens, they call their PO and they get right with your PO.
Because I've been doing good for 13 months.
You need to keep doing good. Be upfront with your PO. Be straight with your PO because this is a temporary situation.
Yeah.
I would stake my life about what these drug results are going to be, but it's not probable cause. It doesn't matter what I personally think. Right. It matters whether the police met the standard. They did not. You are entitled to be released. So get right with your PO. That is the best thing you can do for yourself while this goes through the system. They may well wait for lab results and you don't end up charged for 6 months in this case. The best thing you can do in that situation is be good on probation. So that's sort of life advice, not legal advice. All right, everything's on your paperwork. I did give you a lawyer. I gave you some court dates. Just don't lose it. Call your PO when you get out. They'll help you keep track of your court dates, and everything's on your paperwork.
Thank you.
No problem. Mr. Bender? Hello, sir. Can I have your full name and your date of birth? What's your name, sir?
Robert Bender,
What's your date?
3/29/83.
Okay, thanks. Oh, Mr. Bender, I just saw that you have a DOC hold. Okay. All right. You got arrested for possessing narcotic drugs, a class 4 felony, and drug paraphernalia, a class 6 felony. I'm going to give you a lawyer and a couple of court dates. The first one is a status conference, October 16th. That's 2 weeks from now, 8:30 in the morning. Your preliminary hearing will be October 20th. I did not find probable cause in your case either, which means the police did not provide enough support for the allegation that what you had was narcotic drugs. The case is not dismissed, but I must release you. I just saw that you have a DOC hold, though. So what's going to happen is DOC is going to get notified that you got released. They will get 24 hours to pick you up. If they do, then you deal with them. If they don't pick you up and you hit the street, don't miss your court dates. It's all going to be on your paper because the case is not dismissed. I just have to release you because I didn't find probable cause for the drug.
Okay, can I ask a question?
Sure.
What do you mean by you don't find probable cause?
Oh, it means that, so the police have to give me a minimum amount, it's kind of specific, to establish that what you had was, they're alleging it's powdered fentanyl, but on powder, police aren't, legally speaking, they can't look at powder and go, nah, that's fentanyl. Because sometimes it's meth, sometimes it's cocaine, sometimes it's baby powder. So they have to do a field test, there have to be some things. They didn't do that. So just like in most cases, do I think it was probably fentanyl? Yes. But they didn't meet the legal standard of proof, which means you're entitled to be released while the case moves forward. So I'm releasing you. The case is not dismissed. The county attorney can still go forward. but you are entitled to be released. Your problem is that you also have a DOC hold. So I'm releasing you in this case from this jail, but DOC is going to get a call, and they get 24 hours to come and get you. So I can't help you with that. I got nothing to do with you.
No, I do have a question with that. If DOC comes and gets me,
Yeah.
okay, I go back to prison. What happens with the case when I'm in prison?
If they go forward, it's going to end up in a warrant. It'll be put on you at the prison, and they'll bring you here before you actually get out of prison. If they don't charge it yet, if they wait for lab results, which they often do, you may get out of prison before they charge it. So it just depends on when the county attorney decides to charge it.
Okay, so would I'll be bedded today?
Sorry?
Or would I be put in a bunk
I
today?
don't know.
Or?
Talk to the DOs. I doubt it because now you've been released and they're just waiting to see if your PO comes. So I doubt you might get a mattress if you get 24 hours, but I don't think you're going to get a bed. All right. If you step to your left, you get that paper. All right. Thank you.
Okay, thank you.
Yeah, no problem. All right, Mr. or Officer, I've got Mr. Gutierrez Hernandez and Ms. Marin. As house calls, are they not physically present because they could pose a risk of danger to themselves or others?
Yes, Sean.
All right, I'm going to go to each of those defendants in person in-house immediately after this hearing to conduct their initial appearances in person. I will advise Atanasio Gutierrez Hernandez that he got arrested for dangerous drug possession, class 4 felony, and drug paraphernalia possession, class 6 felony. I did find probable cause, and I am appointing a lawyer for him. His next court date will be a status conference October 8th at 8:30, and a preliminary hearing October 10th at 8:30. And I'm inclined to set bond in his case in the amount of $500 secured for the reasons set forth in my written order. Andrea Marin, born 11/14 of 87, got arrested for aggravated assault on a correctional employee. That's a class 5 felony. And then multiple misdemeanors. Assault, disorderly conduct, 2 counts, criminal damage, and a 3rd count of assault is a class 3 misdemeanor. I will advise her that there is probable cause for those, and I am appointing a lawyer for her. Her status conference, provided I do release her, is going to be October 16th at 8:30 in the morning, with a preliminary hearing October 20th at 8:30. And I am going to release her to pretrial services. That's what's indicated by the risk assessment score, and it's also the state's recommendation. I believe it is appropriate. And my inclination is to order no uninvited contact with the alleged victims or her parents. So I'm going to go talk to her, and it's my hope that she will understand that order and be able to indicate to me that she will comply with it. She really doesn't have any criminal history, and it's not clear to me that her parents will not want to have contact with her. I am going to order no weapons or drugs, no alcohol. She has to obey any order of protection. And again, she's not to have any uninvited contact with the alleged victims, and she can't live with them unless they consent, and that consent must be ongoing. If it's revoked or if they never give it, she has to find alternative residence and bring proof to her next court date. Alrighty, everything is going to be on the paperwork. If anything changes after I see these 2 defendants in-house, my final written order will contain the court's ultimate ruling in these cases. I am not going to update the recording. Thank you. We are in recess.
Not that we know of, it's a no. She said only if you had questions, so I didn't respond. You have the email and have her here. Okay, cool. Great. Bye. Okay.
Uh-oh.
They just need to come in.
All rise.
Thank you, everyone. Please be seated. But no LEDs, right? No LEDs? Okay. All right. Good afternoon, everybody. My name is Commissioner Hughes. This is the 2 p.m. initial appearance calendar for Thursday, October 2nd. The court's orders for the taking of DNA samples and fingerprints issued on the first calendar of October will apply to all of the hearings on this calendar. Is my Teams linked to that Teams?
Yes, your picture is smaller.
How come I can't pin the court?
I have a few.
What do you mean by that? Sorry, if you'll all give me just one quick second.
What are you trying to do?
I want it just that.
Oh, because I have her pinned on.
Oh, okay. Okay, as we get started on the calendar here this afternoon, I will call each of you into the courtroom one at a time. I'll ask one of you to stand behind this gray podium here in front of me in the courtroom. Then I will ask the next either person or two people, depending on how many chairs are out there, to line up in the two blue chairs. Okay, two chairs. I think there's two blue chairs right here facing all of you. If you would, please listen for your name, move from the chair you're in right now to the second chair inside the door, then shift over to the first, then come into the courtroom. I know that sounds a lot like musical chairs. I promise you all it will make this calendar move much faster. So if you will, please listen for your name, move through the chairs into the courtroom. Everybody can get to where they need to go after this court calendar a little bit sooner. Once you work your way into the courtroom, I will start by asking you to state your full name and date of birth. Then I will explain to you why you're here this afternoon. You all have the right to the assistance of counsel in a criminal case. When you're in the courtroom, I will tell you whether the court is appointing a court-appointed lawyer to represent you. Those lawyers are sometimes referred to as public defenders. Whether or not you qualify for a public defender, you always have the right to hire a private lawyer at your own expense to represent you if you wish to. When you're in the courtroom, I will also give you the next court hearing dates and times that you'll be required to attend after this court hearing. And the last thing that we'll do while you're in here is talk about whether you are legally eligible for release from custody today. If you are, we will go over on what terms and conditions you could be released from custody. In addition to that right to the assistance of counsel, you all also have the right to remain silent. These are recorded criminal proceedings. That means anything that you choose to say in the courtroom here this afternoon will be preserved on our recording, and it could be used against you at any point down the line in these proceedings. Unless you have made arrangements with a private lawyer already, there will not be a lawyer in the courtroom to represent you here this afternoon. If you qualify for a court-appointed lawyer, your lawyer will be present to defend you starting at your next court hearing. Because most of you or all of you will not have a lawyer in here this afternoon, but because anything you say could be used against you, I will strongly caution all of you not to make any statements regarding the facts that brought you here. I encourage all of you to save any statements, questions, comments that you might feel inclined to make about the facts that brought you here for a hearing where you have a lawyer present to discuss that with before you make any statements on a recording that you can't take back. Last thing I'll tell you all before we get started is that all of the information you get while you're in the courtroom will be given to you in a written document called a release order. So please don't feel like you need to memorize dates, times, information that you're getting in the courtroom, but please keep that paperwork that you're given when you step back into that room. Keep it with you wherever you go from here, because in that paperwork will be all the information you get in the courtroom, most importantly, your next court hearing dates and times with the address and phone number for those courts. All right, let's go ahead and get started if we could. Can I please have Isaiah Parsons all the way into the courtroom behind the gray podium in front of me? Cesar Penaloza, if I've pronounced that correctly. If you would have a seat in the first blue chair right inside this door. Jerry Swanson, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Isaiah Parsons, 8/21/95.
Thank you, Mr. Parsons. You are here on 3 different matters. The first matter that you're here on is allegations of new charges. Those allegations are 1 count of unlawful flight from a law enforcement vehicle, that's a Class 5 felony, 1 count of resisting arrest, a Class 1 misdemeanor, and 1 count of reckless driving, a Class 2 misdemeanor. I did find probable cause to support those allegations, and I did appoint a public defender to represent you against them. Your next court hearings on those new allegations will be a status conference October 8th, and then you will have a preliminary hearing October 10th. Both of those will be at 8:30 in the morning. They will both be in the Superior Court downtown. On those new allegations, you have a $25,000 cash-only bond. The other 2 matters you're here on are both probation violation warrants. In those cases, petitions to revoke your probation had already been filed. Both of those petitions allege that you have violated term 15 of your probation in each case. Your next court hearing in the 2 probation matters will be a revocation arraignment hearing. It will be October 9th at 8:30 in the Superior Court downtown. I did also appoint a lawyer to represent you in both of those probation proceedings. On the 2 probation matters, you are not eligible for release on bond. That means you will be held in custody without bail at least until you see the probation judge on October 9th. Because of that, I encourage you to wait until after that hearing on the 9th before you attempt to post your bond on the new case. Do you understand that information?
Yes, Your Honor.
Thank you, Mr. Parsons. You can step back and get your paperwork. Cesar Penaloza, if you would please work your way into the courtroom. Jason Hallquist, if you would please work your way to the second chair. It's this one, right? Okay. Can I have your name and date of birth, please, sir?
Cesar Penaloza, 10/20/1986.
1986, not 1988.
No, 86.
Okay. All right. Thank you very much, Mr. Penaloza. And it's my understanding that a lawyer from, I believe, the Attorney General's office intends to appear on this matter. Assuming that's true, can I please have the appearance of counsel for the state?
Rebecca Kennelly on behalf of the Attorney General's office. Good afternoon, Your Honor.
Good afternoon, Ms. Kennelly. Thank you for joining us this afternoon. Okay, Mr. Penaloza, you are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession for sale, 1 count of narcotic drug possession for transportation or sale. Those are both Class 2 felonies. 1 count of conspiracy, also a Class 2 felony. 1 count of illegal control of an enterprise. That's a Class 3 felony. 2 counts of criminal damage, 1 count of possession or use of a weapon in a drug offense. Those 3 allegations are Class 4 felonies. 1 count of unlawful flight from a law enforcement vehicle, which is a Class 5 felony, and 1 count of resisting arrest, a Class 6 felony. I am inclined to find probable cause for those allegations with the exception of the conspiracy and illegal enterprise allegations. I did not see any information in the facts presented to me by law enforcement to support either of those 2 allegations. Before I make that official finding, Ms. Kennelly, is there any argument or additional information the state wishes the court to consider in regards to probable cause?
Sorry, Your Honor. No, I understand looking over the Form 4. It was not clear in what the police provided that he was in the parking lot with the drugs because of an arrangement with another person that he had conspired with. And so I completely understand Your Honor's findings.
Okay. All right. Then hearing nothing that changes my mind, I am finding probable cause to support all of the allegations that I listed except conspiracy and illegally conducting an enterprise. Mr. Penaloza, what that means, well, let me start with what it doesn't mean. It does not mean that those 2 allegations are legally dismissed. It is possible that the Attorney General's office will file charges on the conspiracy or illegal enterprise allegations in some form. But what my finding of no probable cause on those 2 allegations does mean is that I am not considering those 2 allegations for purposes of determining your preliminary release conditions. I did determine that you're entitled to a court-appointed lawyer. I have appointed the Public Defender's Office to represent you. Your next court hearings will be a status conference October 8th, and then you'll have a preliminary hearing on October 10th. They will both be at 8:30, and they'll both be in the Superior Court downtown. Before I consider or impose release conditions, I will say I have received a written recommendation from the Attorney General's office regarding release conditions. That written recommendation requests that I hold you on a $150,000 cash bond. The rationale for that is in large part based on the underlying facts provided to me by law enforcement. Ms. Kennelly, any additional argument or factors you would like the court to consider in regards to release conditions?
Your Honor, just that from the IA form that we all use as a template, there wasn't an option for the flight risk based on his actions that night, which he very clearly was trying to evade any kind of contact with the police to the point where he significantly damaged those 2 other cars to push them out of his way and then ran through that neighborhood, abandoning the kilo of fentanyl powder and a gun in a community trash bin. And so I do think if there was an other box, I would have selected it and asked you to consider that for reasons that he is a flight risk.
Okay, thank you, Ms. Kennelly. Mr. Penaloza, I will give you an opportunity to address the court if you wish to in regards to release conditions. I guess what I'm trying to tell you is the state is asking me to hold you on a $150,000 cash bond. It sounds like based on their representations, it's because they believe that you are a flight risk, meaning that you there's a risk that you will not voluntarily appear in court if you're released, or there's a risk that you would not voluntarily surrender for an adverse verdict in this case, if and when this case gets there. So I'm willing to entertain any information you would like me to consider in regards to what release conditions to impose in your case. Before I do that, though, I will remind you, you don't have a lawyer present here. You can see and hear on the screen that the state's lawyer is here. Anything that you say she will hear could be used against you. So I will let you address the court on release conditions, but I encourage you very strongly not to get into the underlying facts of this case until your next hearing when you have a lawyer present. Okay, if there's anything you want the court to consider in regards to what release conditions to impose, I invite you to present that information now. Nothing?
No, sir.
You don't have to say anything, but if you want to, this is your chance. Nothing? Okay. All right. Thank you, Mr. Penaloza. I have reviewed the underlying allegations in this case. I've reviewed the state's recommendation. I have also reviewed your prior criminal history. I will note that I I guess I should say I reviewed your lack of prior criminal history. My review of that indicates you have no prior felony or misdemeanor convictions. You have no prior failures to appear in court. That said, I do hear and understand the state's argument that based on the underlying allegations in this case, it sure does appear as though there was, at least preliminarily, an attempt to not be apprehended by law enforcement. That does give the court some concern that you would pose a flight risk in this case. Based on all of those factors, I am persuaded that a bond is necessary, based also in part on the amount and quantity of types of drugs allegedly apprehended in this case. I do also have some concern about your flight risk and also potential harm to the community just based on that volume of drugs. I am going to set bond at $25,000. It will be cash only. If you post that bond, I am also ordering that you be affixed with an ankle monitor prior to your physical release from custody. If you post that bond and you are released on that ankle monitor, you cannot have contact with any alleged witnesses of the underlying allegations or any co-defendants if there are any. If you're released from custody, you're also prohibited from possessing any weapons or any drugs without a valid prescription. Anything else I need to address in this matter, Ms. Kennelly?
I don't know if I missed it about the no victim contact, but we do have victims listed in this case for the criminal damage.
Thank you. Yes, I did miss that. I was thinking that the victims were the law enforcement officers. So I'm also going to order that you not have contact with any alleged victims. That means you can't reach out to anybody that allegedly suffered harm or damage in this case because of the alleged actions. Okay. One more time, anything else, Ms. Kennelly?
No, thank you, Your Honor.
Okay, thank you. Mr. Penaloza, do you understand your release conditions?
Yeah.
Okay, I'm going to get your paperwork reprinted for you. One of the officers will bring it out to you if you'll take a step back to your left. Thank you, sir. Ms. Kennelly, you are free to join me for the rest of the calendar and observe. You're also free to be excused if you wish to. I will take no offense.
Thank you. Have a good day.
You too. Thank you. All right, Jerry Swanson, if you would please work your way into the courtroom. Alexander Moody, if you would please work your way to that second chair. Can I have your name and date of birth, please, sir?
Jerry Swanson, 8/31/61.
Thank you very much, Mr. Swanson. You are here on allegations of new charges. The allegations against you are 1 count of aggravated assault with a deadly weapon, that is a Class 2 felony, 1 count of disorderly conduct involving weapons, 1 count of discharging a firearm in the city limits, those are both Class 6 felonies, and finally 1 count of criminal damage, a Class 1 misdemeanor. I did find probable cause to support those allegations, and I have appointed a public defender to represent you. Your next court hearings will be a status conference October 8th and then a preliminary hearing October 10th. Both of those hearings will be at 8:30 in the morning. They'll both be in the Superior Court downtown. On these allegations, I have imposed a $25,000 secured appearance bond. Secured appearance means you do have the option of using a bonding company to post that bond if you choose to. If you do post that bond and you're released from custody, you cannot return to the scene where the underlying alleged events took place or have contact with the alleged victim of these offenses. You also could not possess any weapons or consume any alcohol or drugs without a valid prescription if you are released from custody. Do you understand those conditions?
What is preliminary conference?
So, nothing. Your first hearing is a status conference.
Status conference?
Your second hearing is a preliminary hearing. So your first hearing at the status conference, that's your first opportunity to talk to your lawyer and talk to the judge that will see you on the underlying facts of the case. At that status conference, before your case is called, you'll have an opportunity to consult with your lawyer. That status conference will also potentially set the calendar and rest of the dates for the remainder of this case, depending on what the conversation with you and your lawyer looks like.
And that's on the 8th?
That's on October 8th, that's right.
Okay.
All right, thank you, Mr. Swanson. You can step back and get your paperwork. Jason Hallquist, if you would please work your way into the courtroom. David Cuevas, if you would work your way to the second chair, please. Can I have your name and date of birth, please, sir?
Jason Hallquist, August 2nd, 1983.
Thank you, Mr. Hallquist. You are here on allegations of new charges. The allegations against you are 1 count of burglary, that's a Class 3 felony, 1 count of aggravated assault, a Class 6 felony, 1 count of interfering with judicial proceedings, 1 count of criminal damage. Those 2 are Class 1 misdemeanors. And finally, 1 count of preventing the use of a telephone in an emergency. That's a Class 2 misdemeanor. I did find probable cause to support those allegations, and I have appointed a public defender to represent you. Your next court hearing will be a status conference October 8th, and then you will have a preliminary hearing October 10th. They'll both be at 8:30 in the Superior Court downtown. On these allegations, you have a $15,000 secured appearance bond. If you post that prior to your release from custody, you will be ordered to have an ankle monitor installed on your ankle for electronic monitoring. If you post that bond and you are released on an ankle monitor, you cannot go back to the scene where the alleged underlying events took place. You cannot have contact with the alleged victim. If you're released from custody, you would be prohibited from possessing any weapons, drugs without a valid prescription, or alcohol. Whether or not you're released from custody, you would also be ordered to strictly comply with the terms of any orders of protection, if any have been or are later served upon you. Do you understand those conditions?
Mm-hmm.
Okay, thank you, Mr. Hallquist. You can step back and get your paperwork. Alexander Moody, if you would please work your way into the courtroom. Sam Spears, if you would work your way to the second chair, please. Can I have your name and date of birth, please?
Alexander Faustino Moody, 8/21/02.
Thank you very much, Mr. Moody. You are here on 4 different matters. The first one is an allegation of a new charge. That allegation is 1 count of shoplifting. It is a Class 4 felony. I did find probable cause to support that allegation, and I've appointed a public defender to represent you against it. Your next court hearings in that felony case will be a status conference October 8th and then a preliminary hearing October 10th. Both of them will be at 8:30 in the Superior Court downtown. On that new felony allegation, you have a $7,500 secured appearance bond. The other 3 matters you're here on are all post-adjudication warrants issued by the Peoria Municipal Court in 3 different misdemeanor shoplifting cases. In all 3 of those Peoria cases, you're entitled to a court-appointed lawyer for purposes of release conditions. That lawyer in those 3 Peoria cases will be appointed by the Peoria judge at your next hearing. Your next hearing on those 3 warrants will be an arraignment hearing October 7th. That one will be at 9 o'clock in the morning in the Peoria Municipal Court. On each of the 3 Peoria warrants, you have a $100 secured appearance bond. So $300 for Peoria, $7,500 on the new felony. That makes your total bond $7,800. It is all secured appearance. If you post that and you're released, you cannot go back to the scene where the alleged new shoplifting offense took place. You also could not have contact with any alleged witnesses of that offense. And if you're released from custody, you could not possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you, Mr. Moody. You can step back. David Cuevas, if you would work your way into the courtroom, please. Demetria Wright, if you would please work your way to the second chair. Can I have your name and date of birth, please?
David Cuevas, 10/18/1990.
Thank you, Mr. Cuevas. You are here on a bench warrant issued by the Superior Court when you failed to appear at a sentencing hearing in an existing case involving felony drug and misdemeanor shoplifting allegations. You have a lawyer already assigned to you in that case. That lawyer will stay on and continue to defend you. Your next court hearings will be... One second. Tracy, is that right? Shouldn't it be post-warrant status? It was a sentencing hearing. Yeah, on 9. So he's past status and prelim. The warrant says sentencing. Let me check. I want to make sure I get, yeah. So the warrant says that you failed to appear at a sentencing hearing.
I think it was supposed to be, we're supposed to negotiate the time or how much time or they were trying to give me or whatever.
Did you already take a plea?
No, well, there was a plea offered, but I didn't go to the court or whatever, right? I had just recently talked to my lawyer last Monday. We're supposed to schedule another court date this week, but I ended up getting caught up.
I just want to see.
Just to squash
I want to set you for the correct hearing. I don't want to set you for a hearing that you don't need, and then you go to that hearing and they reset it for the right hearing. I'm trying to get you on the fastest track possible to try and get this resolved.
Okay.
So I just want to make sure I get your hearing type right. I don't know. It doesn't look like he ever did have this status. I don't know why it says sentencing. It was set for dispo though, right?
This one?
Yeah, the last hearing, it looks like it was oh, maybe not. I swear I thought I just saw a dispo hearing. Have you been to a hearing in this case already? Or have you not yet been to the judge downtown on this case?
I've been to one hearing, but then, like I said, we're supposed to, try to figure out how much time, I was trying to get a better plea, really. Try to get a better sentence.
Do you know when that hearing was that you did attend?
I don't, it was like last month or something. I'm not too sure. I was only out for
Could it have been in August?
Yeah, I think it was August. I was only out for like a couple weeks, really. But I just didn't know sentencing was going to come so quick, you know? I thought you had a settlement conference.
That
and stuff
may
like that.
have, yeah, that's what I'm trying to figure out, is if that was an accident that it said sentencing in the warrant, or if it really was a sentencing hearing.
No, I think it was a settlement conference, I think, because I don't think I had gone to a settlement conference.
Oh, okay. Let me see.
I'm not too sure, though.
Like I said, I just want to get your hearing right. It looks like it was a status conference.
It was, huh?
Yeah, so it looks like the warrant had the wrong information, but the minute entry that issued the warrant was right. So it looks like it was a status conference that you missed. So those hearings in your release order are going to be correct. So you'll have a new status conference October 8th, and then you'll have a preliminary hearing October 10th. They'll both be at 8:30 downtown. So at that status conference on October 8th, your lawyer will be present. You and your lawyer can pick up where you left off at the last hearing that you were at. On that warrant, you do have a $2,500 secured appearance bond. If you post that, you will be responsible for getting yourself to that court hearing on October 8th. And if you're released from custody, the same release conditions that were previously in place in this case will continue to remain. Those include that you can't go back to the scene where the underlying alleged shoplifting offense took place, if you know where that was, and you could not possess any weapons or drugs without a valid prescription if you're out of custody. Okay, sorry for the confusion, but I'm glad we got it right. Do you understand your release conditions?
No. So what was the release conditions?
So you have a $2,500 bond.
Okay.
So if you post that bond,
Okay.
you will get out of custody, and then you have to go to court on your own because you'll be out of custody. So you got to get yourself to court on October 8th. And between the time that you get out of custody, if you post that bond, and at least that hearing on the 8th, you can't go back to where the shoplifting offense took place.
Okay.
You could not possess weapons, and you couldn't possess drugs without a valid prescription.
Okay.
All right. Thank you, Mr. Cuevas. You can step back and get your paperwork. Sam Spears, if you would please work your way into the courtroom. Olson Sway, if you would work your way to the second chair. Can I have your name and date of birth, please, sir?
Sam Spears, February 20, 1976.
Thank you, Mr. Spears. You are here on 3 different matters. The first matter that you're here on is allegations of new offenses. Those allegations are 1 count of resisting arrest, 1 count of drug paraphernalia possession. They are both Class 6 felonies. 1 count of tampering with physical evidence, that's a Class 1 misdemeanor. 1 count of obstruction, and 1 count of failing to obey law enforcement. Those last 2 are Class 2 misdemeanors. The other 2 matters you're here on are both allegations that those new charges violate Term 1 of your probation in both of those cases. I did find probable cause to support the new allegations, which means I also found probable cause to support those term 1 probation violations. I have appointed a lawyer to represent you in all 3 cases. Your next court hearings on the new case will be a status conference October 8th and then a preliminary hearing October 10th. Your next court hearing in the probation cases will be a revocation arraignment October 9th. So 8, 9, and 10, all of them will be at 8:30. They'll all be in the Superior Court downtown. On the new case, you have a $2,500 secured appearance bond. On each of the probation cases, you have a $250 secured appearance bond. That means your total bond for all 3 cases will be $3,000. If you post that and you are released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you, Mr. Spears. You can step back and get your paperwork. Demetria Wright, if you would please work your way into the courtroom. Shamar Cheres, if you would work your way to the second chair, please. Right behind this podium, yep. Can I have your name and date of birth, please?
Demetria Wright, 12/16/03.
Thank you, Ms. Wright. You are here on allegations of new charges. Those allegations are 1 count of assault and 1 count of disorderly conduct. They are both misdemeanor allegations. You are entitled to a court-appointed lawyer to represent you against those allegations. That lawyer will be appointed for you at your next court hearing by the next judge you see. That hearing is going to be an arraignment hearing October 8th. It will be at 1 o'clock in the afternoon, and it'll take place in the Buckeye Municipal Court. On those allegations, you have a $500 secured appearance bond. If you post that bond and you are released from custody, you could not go back to the location where the underlying alleged events took place. You could not have contact with any alleged victims or witnesses of those allegations. If you are released from custody, you could not possess any weapons, you could not consume any alcohol or drugs without a valid prescription, and if any orders of protection have been served upon you or if any are later served upon you, whether or not you're released from custody, you would be required to strictly comply with the terms of those orders. Do you understand those conditions?
Kind of, so I'm confused, no release, or...
Say that again, you're confused what?
On the release, so I won't be being released or I will be being released.
You have a bond. So if you post that bond, you will be released from custody on this matter. If you do not post that bond, you'll stay in custody at least until your first hearing on October 8th. MCSO would transport you to that court hearing, and then what happens after that would be up to the judge you see on the 8th.
Okay.
Okay, any other questions, Ms. Wright?
I don't even know, to be honest.
Okay, well, all this information that you got will be in your release paperwork, so you'll get a copy of that paperwork when you step back to your left. You can have the opportunity to look it over, and you can always use any of the phones in the jail to call friends, family, as long as it's not the alleged victim. Otherwise, you can wait until your first hearing on the 8th, and that Buckeye judge will give you a lawyer that can help you navigate this case. All right, thank you, Ms. Wright. You can step back and get your paperwork. Olson Sui, if you would work your way into the courtroom, please. Mika Ross, if you'd work your way to the second chair. Can I have your name and date of birth, please?
Olson Sui, April 9, 2001.
Thank you very much, Mr. Sui. You are here on a bench warrant issued by the Superior Court when you failed to appear at a status conference. The underlying allegations in that case are felony drug and misdemeanor trespassing allegations. You have a lawyer already assigned to represent you in that case. That lawyer will continue to defend you.
Okay.
Your next court hearings will be a new status conference October 8th and then a preliminary hearing October 10th. They will both be at 8:30 in the Superior Court downtown. On that warrant, you have a $500 secured appearance bond. If you post that bond and you're released from custody, you cannot possess any drugs without a valid prescription. You also could not go back to the scene where that underlying alleged trespassing offense took place if you know where that is. Do you understand those conditions?
Yes, ma'am.
All right, thank you very much. You can step back and get your paperwork. Shamar Cheres, if you would work your way into the courtroom, please. Shauna Ibarra, if you'd work your way to the second chair. Can I have your name and date of birth, please?
Shamar Cheres, August 31st, 2000.
Thank you very much, sir. You are here on a child support arrest warrant. The family court judge in your family case has issued a cash purge on that warrant in the amount of $478. That cash purge is the amount that you would be required to pay in cash in order to secure your release from custody. If you posted that cash purge, you would get out of custody. If you did not, you would remain in custody and be transported to your next court hearing. Whether or not you're in custody or out of custody, you are required to appear at a return hearing on this warrant. That hearing will be October 7th at 10 o'clock in the morning. It'll be in the family court downtown. Under Arizona law, I cannot reduce, modify, or eliminate the amount of that cash purge. I am, however, required by law to ask you 2 questions. Before I ask you these questions, I will tell you you are not under any obligation to answer these questions. You can simply say, no, thank you, pass, move on, whatever. You're free to answer them if you wish to, but I don't want you to feel like you're compelled to provide an answer if you don't want to. First question is there anything you want the court to know about your present ability to pay that cash purge?
Same reason why it's been stacking up a little bit. It's hard for me to get the full payment of it, which is why it's been here for a moment.
Okay, second question. Again, you don't have to answer this if you don't want to. You're free to answer it if you do want to. Is there anything you want the court to know about being held in custody until that cash purge is paid?
It might be difficult to get it paid. I sure will try, but, you know, it's difficult because I won't be able to get some money or make the money. I don't have the cash on me.
Okay. Okay, thank you for those answers, Mr. Chairez. As I indicated, I don't have the authority to reduce, eliminate, or modify that amount, so you will have to post that $478 cash purge in order to secure your release. Please remember that whether or not you post that, you have to go to that hearing October 7th at 10 o'clock downtown. So if you do get that posted and you're out of custody, do what you have to do to make sure that you're in court at 10 o'clock on October 7th. If you don't post that and you stay in custody, MCSO will make sure you're at that hearing. Okay, any questions?
No, ma'am.
All right, thank you, sir. You can step back and get your paperwork. Mika Ross, if you would please work your way into the courtroom. Sean Van Hosen, if you would work your way to the second chair, please. Will you pull your arms out of your shirt for me, please, and then give me your name and date of birth?
My name is Micah Ross. Date of birth is 06/12/2000.
Thank you, Ms. Ross. I apologize for getting your first name wrong. Okay, you are here on an allegation of a new charge. That allegation is 1 count of aggravated assault on a first responder. It is a Class 5 felony. I did find probable cause to support that allegation, and I have appointed a public defender to represent you. Your next court hearings will be a status conference October 16th, and then you will have a preliminary hearing October 20th. Both of those hearings will be at 8:30. They'll both be in the Superior Court downtown. I am inclined to release you to the supervision of pretrial services. That means you would get out of custody without having to post a bond. Upon your release from custody, you would be responsible for getting yourself to your hearings on the 16th and the 20th downtown. You would also be responsible for making contact with pretrial services upon release. With your paperwork, you would get a packet from pretrial services. Their contact information would be in that packet. So once you're out of custody, you would have to go in that packet, get their phone number, and give them a call. Also, once you are released from custody, you would be ordered not to initiate contact with the underlying alleged victim law enforcement officers. You also could not possess any drugs without a valid prescription once out of custody. Do you understand those conditions, Ms. Ross, and do you agree that you'll abide by them if you are released without a bond?
I don't understand. You said that you found the probable cause. That means I got, I'm charged for it then.
Well, no formal charges have been filed yet. So what my finding of probable cause means is that the information provided to me by law enforcement about what is alleged to have happened in this case, if true, would meet the minimum elements of the crime of aggravated assault on a first responder. Okay. You have the opportunity through your lawyer starting at your next court hearing to challenge that information. You also have every right to present defenses to that allegation if your lawyer thinks that you have any. So you have not formally been charged at this point, but the information law enforcement has given me would meet the minimum elements of the crime if the county attorney's office does elect to charge this case. So you'll get out of custody today. Once you're out, call pretrial services. They can offer you some limited assistance in kind of understanding what happens next, helping you get connected to the court, your lawyer's office. But the most important thing for you to know leaving this courtroom is that you have to go to court on October 16th at 8:30 downtown.
Okay.
When you go to that court hearing, your lawyer will be present. Your lawyer can spend much more time with you talking about the underlying facts and what steps will happen next.
Okay.
So once you leave the courtroom, or I guess once you get out of jail, use the packet that the officers hand you when you get back into that room. Use that phone number to call pretrial services. And if you remember nothing else from this hearing, remember you have to go to court downtown on October 16th.
Okay, I'll write them down. Thank you.
You have it in that, it'll be in that
Okay,
paperwork. So just keep that and put it in your phone, write it on your calendar, however you keep track of dates. Make sure you get yourself downtown on the 16th.
Okay,
All right, thank you, Ms. Ross. You can step back. Shauna Ibarra, if you would please work your way into the courtroom. Anthony Milligan, if you would please work your way to the second chair. What'd you say? Take your time, take your time. We're not going anywhere. All right, can I have your name and date of birth, please?
Shauna Light Ibarra, 12973.
Thank you, Ms. Ibarra. You are here on an arrest warrant that was issued after a direct complaint was filed. A direct complaint is a written document that alleges new allegations against you as opposed to new allegations by law enforcement on an arrest. The allegations in that direct complaint are 1 count of narcotic drug possession, that's a class 4 felony, and 1 count of drug paraphernalia possession, a class 6 felony. The direct complaint alleges that those offenses were committed September 26th of 2023. I did appoint a lawyer to defend you against those allegations. Your next court hearings will be a status conference October 16th, and then you will have a preliminary hearing October 20th. Both of them will be at 8:30 in the Superior Court downtown. I am inclined to release you on your own recognizance on this warrant. That means you would get out of custody without having to post a bond. You would be responsible for getting yourself to your first court hearing and your second court hearing on October 16th and 20th. Upon release, you would also be ordered not to possess any drugs without a valid prescription.
May I say something?
You may, but I would be very cautious if I were you, because anything that you do say could be used against you.
Everything, I've had back surgeries and hysterectomies and whatnot. So everything I've had my name on it.
Okay, I don't know exactly what you mean by that, but
My
that's okay.
medication that he took from me.
So what I would say is at your next court hearing, talk to your lawyer. Talk to your lawyer about the underlying facts. I don't know. All I have is the warrant that says that these charges were filed against you. I don't have a factual summary about what is alleged to have given rise to those allegations, but your lawyer will have that information at your next court hearing. So when you go to court on the 16th, tell your lawyer, I've had a lot of surgeries, I've been prescribed a lot of medication. Your lawyer can tell you what the underlying facts giving rise to these charges are, and then you could say, oh, I had a prescription for that, and you and your lawyer can work on that and present that as a defense. Or you might say, oh, I remember that now, okay, and then you and your lawyer figure out how to go forward. But I don't have those facts, so talk to your lawyer when you get to your next court hearing.
Okay. Would it help if I brought in my statements from my pharmacist to court?
I don't know, because I don't know the facts about the underlying case. If you think that might help, what I would say is bring anything to that hearing that you think might be helpful. Show it to your lawyer. Talk to your lawyer about that. If it is helpful, your lawyer can present it to the court. If not, your lawyer might just say, thanks for that information. We'll save that for later.
Okay.
All right. Any other questions?
No.
All right. Thank you, Ms.
Thank you.
You can step back and get your paperwork. Sean Van Hosen, if you would work your way into the courtroom, please. Adrian Baca, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Sean S. Van Heusen, 3/14/1980.
Thank you very much. Your last name is pronounced Van Heusen?
It's Van, it's two separate words, Van and Heusen, yes.
Heusen is how it's pronounced, but is it spelled Hoesen?
That is correct.
Okay, thank you, Mr. Van Heusen. You are here on allegations of new charges. The allegations against you are 1 count of dangerous drug possession, that's a class 4 felony, and 1 count of drug paraphernalia possession, which is a class 6 felony. I did find probable cause to support those allegations, and I have appointed a public defender to represent you. Your next court hearings will be a status conference October 16th, and then you will have a preliminary hearing October 20th. They will both be at 8:30 in the Superior Court downtown. I am inclined to release you on your own recognizance. That means you would get out of custody. You would not be required to post a bond. Upon your release from custody, you would be responsible for getting yourself to both of those next court hearings. And upon release, you could not possess any drugs without a valid prescription. Do you understand those conditions and agree that you'll abide by them if released without a bond?
May I speak?
Yes, same warning I've been giving everybody, though. Be very careful about what you say because anything you say could be used against you.
That's fine. Let's just leave it at released because I can't move forward without my attorney.
Okay, so then you'll get released from custody. Please make sure that you get yourself to court on the 16th at 8:30 because your lawyer will be present at that hearing, and then you'll have an opportunity to say anything you want to your lawyer, and your lawyer can then decide whether or not to present that information to the court. Okay, thank you, sir. You can step back and get your paperwork. Anthony Milligan, if you would please work your way into the courtroom. Jerry Clymer, if you would work your way to the second chair, please. Can I have your name and date of birth, please, sir?
Anthony Milligan, 22476.
Thank you, Mr. Milligan. You are here on 2 failure to comply with court terms warrants. They are both issued by the Hacienda Justice Court, one on a misdemeanor assault case, the other on a misdemeanor disorderly conduct case. Because the underlying warrants are post-adjudication misdemeanor matters, you're not entitled to a court-appointed lawyer. If you don't already have a lawyer in either of those cases, but you want one to represent you moving forward, you will have to hire a lawyer at your own expense. Your next court hearing on both of these warrants will be an arraignment hearing October 22nd. It'll be at 9 o'clock in the morning in the Hacienda Justice Court. I am inclined to release you on your own recognizance on both warrants, so you would get out of custody. You would not be required to post a bond. Once you're out of custody, you would then be responsible for getting yourself to that next court hearing on the 22nd at 9 o'clock. And upon release from custody, you would be prohibited from possessing any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Milligan. You can step back and get your paperwork. Adrian Baca, if you would please work your way into the courtroom. Gabriel Rivera Perez, if you would please work your way to the second chair. Officers, did he get the FOJ card? Outstanding, thank you. Can I have your name and date of birth, please?
Adrian Baca, April 11th, 1992.
Thank you, Mr. Baca. You are here on a failure to appear warrant issued by the Arcadia Biltmore Justice Court. It looks like the underlying allegations in that case are misdemeanor false reporting and misdemeanor drug paraphernalia possession allegations. Because those are both misdemeanor offenses, you're not entitled to a court-appointed lawyer at this hearing. If you don't already have a lawyer representing you in that case, but you do want one, you will have to hire a lawyer at your own expense. Your next court hearing on that warrant will be an arraignment hearing October 22nd. It will be at 1 o'clock in the afternoon in the Arcadia Biltmore Justice Court. I am inclined to release you on your own recognizance. That means you would get out of custody. You would not be required to post a bond. Once you were out of custody, you would then be responsible for getting yourself to that hearing the 22nd at 1 o'clock. In your release paperwork, you'll have that date, time. You'll also have the phone number and address to the court. So if you don't know where it is, you can call them to get directions or put it into your GPS. Once you're out of custody, you would also be ordered not to possess any drugs without a valid prescription. Do you understand those conditions, Mr. Baca? And
Yes.
do you agree you'll abide by them?
Yes, ma'am.
All right. Thank you, sir. You can step back and get your... Yeah.
I have a question, ma'am.
Sure.
I went to a court yesterday in Pinal County.
Okay.
And they gave me that I have the court in Maricopa County Superior Court tomorrow, October 10th, actually.
Okay.
Is it the same court or?
No. Well, I can't say for sure because I don't know what that is, and I don't know what. It sounds like you're telling me you were arrested in Pinal County on a Maricopa County warrant, and the Pinal County court gave you a Maricopa County hearing. But from what you just told me, that hearing is in the Maricopa County Superior Court. Where I'm sending you is to the Arcadia Biltmore Justice Court. So I think it's probably a different case, and I think it's probably a different court, but I can't say for sure. So what I would do if I were you is keep that paperwork, look at the address to the court. Do you have the address to the court in that paperwork? So look at that court address and then compare it to the court address on the paperwork you're about to get from this court. If they're the same, perhaps you could talk to the court and try and get everything resolved on that first date. But if they're different, make sure you go to both hearings at each location. Or each hearing at its own location. Okay, anything else?
That's it, ma'am.
All
Thank you very much.
Thank you, Mr. Baca. You can step back. Jerry Clymer, if you would please work your way into the courtroom. Can I please have your name and date of birth?
Jerry Clymer, 3/7/1952.
Thank you very much, Mr. Clymer. You are here on an arrest warrant that was issued after a direct complaint was filed. A direct complaint is a written document that alleges new allegations against you. The allegations in that direct complaint are 1 count of narcotic drug possession, 1 count of dangerous drug possession. They are both class 4 felonies, and 1 count of drug paraphernalia possession, which is a class 6 felony. All 3 of those offenses, according to that direct complaint, are alleged to have been committed August 14th of 2024. I have appointed a lawyer to defend you against those allegations. Your next court hearings will be a status conference October 16th, and then you will have a preliminary hearing October 20th. They will both be at 8:30 in the Superior Court downtown. I am inclined to release you on your own recognizance. That means you would get out of custody today. You would not be required to post a bond on these allegations. Once out of custody, you would be responsible for getting yourself to your court hearings downtown on the 16th and the 20th. And once you get out of custody, you could not possess any drugs that you don't have a valid prescription for. Do you understand those conditions, Mr. Clymer?
Yes, ma'am.
Okay, thank you, sir. You can step back and get your paperwork.
Okay. I just had one question.
Oh, sure, go ahead.
I have real bad health problems. I'm a veteran, and I was going into the Veterans Hospital.
Okay.
Is there any way I can do something to get into the hospital, or do I have to go through all this before?
Well, I don't know the answer. I don't know what your conditions are. I don't know what the VA would require to admit you. So I don't know how to answer that question, but there's nothing about this case that will prohibit you from attempting to go to the VA. Just be mindful of your hearing on the 16th. So if you go there and you're admitted and you can't make your court hearing, you'll want to either call the court or call the public defender's office. You'll have both the phone numbers in your paperwork. Communicate with them so they know you're not present, and then your lawyer could try to move that hearing. So I don't know whether you could get into the hospital, but I'm not stopping you from going to the hospital. Just please be mindful of that court date, because if you're not at that court hearing, that court's going to issue a warrant for your arrest. Okay. Anything else?
No.
All right. Thank you, sir. You can step back and get your paperwork. Okay, Gabriel Rivera Perez, if you would please work your way into the courtroom. Can I please have your name and date of birth?
Yes, my name is Gabriel Rivera Perez. My date of birth is August 6, 1996.
Thank you very much, Mr. Perez. You are here on a failure to appear warrant issued by the state of Kansas.
I just want to know what is that specifically.
What?
I want to know. I think that got me by surprise. I don't know what is that at all.
Well, so I have limited information because it's coming out of the state of Kansas, but what it means is the state of Kansas has issued a warrant for your arrest. It looks like on underlying allegations of larceny or theft, and that's...
What is that?
Well, it's a criminal allegation. So sometime, somewhere in Kansas, a criminal complaint or a criminal charge against you for theft or larceny was filed. The Kansas court has now issued a warrant for your arrest on those allegations. I am not seeing you on those underlying allegations in Kansas. I don't know anything about the facts. I don't know anything about the procedure in
Got me by
Kansas.
surprise. I'm here.
What I'm seeing you on is that arrest warrant that was issued by Kansas. So Kansas has told the Arizona court that is a valid arrest warrant, and Kansas has indicated to Arizona that they intend to come to Arizona and take you back to Kansas. That process is called extradition. So Kansas has said, we want to extradite this individual. They want to take you back to Kansas. Because you're here on an out-of-state warrant, your hearing is going to look a little bit different than everybody else that has already gone. You will have a choice between two different options to make. I will tell you what those two options are. Hopefully it will match the information you read on that card. I'll give you an opportunity to ask any questions that you might have about those two options, and at the end I will ask which option you pick. So my first question for you is, did you receive that big laminated card to review?
Yes.
And did you read that card?
Yes, I read it.
Okay. As I indicated, a warrant was issued for your arrest by the state of Kansas. You will have a choice between two different options to pick from here today. You can choose to waive your right to an extradition hearing and agree to be sent back to Kansas within 30 days, or you can demand to have an extradition hearing held here in Arizona, and then a governor's warrant would be required from both the governor of Arizona and the governor of Kansas before you could be returned to Kansas. If you choose to waive your right to an extradition hearing, I will call that option 1. If you choose to waive your right to an extradition hearing, you would be held here in Maricopa County without bond for up to 30 days to allow Kansas authorities an opportunity to come get you.
What happened if the 30 days pass?
If 30 days pass and they do not come get you, you would be released from custody.
Well, the options I got to be released because.
Well, let me go through. That was only one option.
Okay.
But in that first option, if you have any pending criminal charges here in Arizona, that 30-day time clock would not start ticking until the Arizona charges were resolved. So if you don't have pending Arizona cases and you pick option 1, your 30-day time clock would start tomorrow. So if you pick option 1, starting tomorrow, Kansas would have 30 days to come get you. If you don't like that option, your second option is to demand to have an extradition hearing held. If you pick that second option, I would set an extradition hearing for October 13th. It would be at 1:30 in the afternoon in the Superior Court downtown. Extradition proceedings in Arizona are civil in nature, not criminal. What that means is if you pick that second option and I set that extradition hearing, you would not be entitled to a court-appointed lawyer, but you would have the right to hire a lawyer to represent you in the extradition proceedings if you wanted to be represented. On the Kansas warrant, if you pick option 2, you are bond eligible. So if you pick option 2 and I set that extradition hearing, you would have a $25,000 secured appearance bond. You could use a bonding company to post that bond if you wanted to. If you posted that bond, you would be eligible for release from custody. You would be required to stay in Arizona, and you would be required to get yourself to your first hearing on the 13th and then any subsequent hearings set if there are any in the extradition proceedings. If you pick option 2 and I set that bond and that hearing, governor's warrants would then be sought by the governors of Arizona and Kansas. Both of them have to be signed before you could be taken back to Kansas. The process of obtaining a governor's warrant could take up to 90 days, but you would remain bond eligible for that full 90-day period. Okay, do you have questions about either of the two options?
I don't know. What is that? I don't know what is going on right now.
Okay, so.
But I understand you say there are 2 options, about 30 days and 90 days, second bond, yes.
Yes, second one you're bond eligible, first one you're not. First one you don't get a hearing, second option you do get a hearing.
The first option I don't get a hearing?
You don't get an extradition hearing in Arizona. So if you pick the first option, you're waiving your right to that hearing, and you're agreeing that Kansas can come and take you back. So if you...
I can't go to Kansas.
Okay.
My life is here.
But,
Yeah, that's fine. Then we'll set that hearing. So if you don't agree to go back to Kansas without a hearing, then we'll set that hearing October 13th. It'll be at 1:30 in the afternoon. That'll be your first process in the extradition
how long
proceeding.
are gonna be like in custody? Like,
Well, so you have a bond. So I'm going to set that hearing. I'm going to impose that bond. So if you walk out of here and that bond gets posted, you'll get out of custody. So you stay in custody unless and until that bond is paid on the warrant. So you can use a bonding company to get that bond posted on your behalf if you want to. Somebody could post that bond for you.
I can't do it myself?
You could do it yourself with money on your jail books, but if you don't have any, it would likely take a long time to get money on your jail books. I don't know exactly how that process works, but the jail staff back in the jail is much better versed in how to get bonds posted than I am. So
that means if they put like a bond on me right now, they can hold me for 90 days in here.
Potentially. They could hold you for up to 90 days during the extradition proceedings if you don't post that bond. That's right.
Like I can stay here like 90 days?
Well, you wouldn't stay here in this facility, but if you don't post that bond, you could potentially spend up to 90 days in custody, yes.
I would prefer 30 days then.
30 days, you don't get a hearing, and Kansas is going to come get you. So that's the difference, right? So it's not just 30 days versus 90 days. It's 30 days and you're waiving a substantive legal right to a hearing, or 90 days and you get the right to a hearing.
And what is the difference of the right with the hearing?
You have a right to contest the extradition proceedings.
Like you say, like fight the case.
Fight extradition. Yes, the extradition court is not going to see you on the underlying criminal allegations in Kansas. The extradition proceedings are going to determine whether Kansas has a legal right to come to Arizona and take you back to Kansas.
And they can hold me there for 90 days. Like
well, the state of Arizona can keep you in custody for 90 days on that warrant if you don't post that bond.
Exactly.
But if you pick option one, you don't have the option of posting a bond. And you also don't have the option to contest extradition. You would, in fact, have to waive that right.
Like, I'll have to wait 30 days, and then if they come get me or not, then I don't know. Something like that. I got it.
So you understand the two options?
Yeah.
And which one would you like to pick?
Option one.
You want to waive your right to an extradition hearing and agree to go back to Kansas?
I don't want to go there, but...
So here's the deal. In order for me to accept a waiver of extradition, I have to find that you are knowingly, intelligently, and voluntarily making that choice. And from what I'm hearing from you, you don't want to go back. You're not agreeing to go back to Kansas. So what that means is the only option I have is to set that hearing. So because you're not voluntarily agreeing to go back, you will have to go to that extradition hearing. It'll be October 13th. It'll be at 1:30, and you'll have that $25,000 bond. So you could post that bond and get out of custody.
I can't do it myself.
Well, like I said, talk to MCSO. I mean, you could try to self-bond out. I don't know how easy that is, and I don't know how long that might take, but I think that's an option, but they could give you more information on that.
Okay. Well,
all right.
I've got a question, missing. I prefer to get the option one.
I understand you saying you prefer that, but you're also telling me that you don't want to go back to Kansas. And so I cannot make the legal findings that I'm required to make to accept your waiver. So I have no option but to set that hearing at this point.
It's just, it's because when I got arrested, they didn't grab my wallet. If they send me to Kansas, I'm not going to be able to fly back to Arizona. It's going to be complicated. I'm gonna get lost. I'm gonna get in the street. I'm gonna be lost. So I just prefer to stay here.
Okay. Well, that's what we're gonna do right now. You're gonna stay here at least until the 13th for your hearing. And when I say here, I mean in Arizona.
The 30 days you say.
I've already explained to you. At this point in the proceedings, I cannot accept a waiver from you because you're saying you don't agree to go back to Kansas. So I have no choice at this point but to set that hearing.
So I'm gonna be in jail for 90 days then?
Well, you have a hearing on the 13th and you have a $25,000 bond. Whether or not you stay in jail depends on what you do with those circumstances.
If you said if I don't get the bond, like if I don't pay the bond, I can have the bond for 90 days.
You
Yeah,
are bond
bond
eligible
over.
that whole time period.
Yeah,
It could
but,
be
if I don't-
potentially 90 days.
Yeah, if I don't put the bond, I'm gonna stay the 90 days in there for waiting.
Potentially, you could. I don't know that you will for sure. I don't know. It's possible you could be in custody for up to 90 days.
Yeah.
Yeah. All right, thank you very much, Mr. Rivera-Perez. If
So,
you'll step back to your left, we'll bring your
That means
paperwork out to you.
I didn't have no choice for the first choice.
I don't have the choice to accept that at this point. I signed it, right? Okay. All right, that concludes the 2 p.m. initial appearance calendar. This court will stand in recess until 5 p.m.